I call on Government Orders of the Day, numbers 3 to 6.
Coroners Amendment Bill, Committee Stage, continued. Riccarton Racecourse Development Enabling Bill, Committee Stage. Riccarton Racecourse Bill, Committee Stage. Social Security, Extension of Young Persons Services and Remedial Matters Amendment Bill, Committee Stage.
I declare the House in committee for further consideration of the Coroners Amendment Bill and for consideration of the Riccarton Racecourse Development Enabling Bill, the Riccarton Racecourse Bill and the Social Security Extension of Young Persons Services and Remedial Matters Amendment Bill. Mr. Chairman.
Mr. Speaker. The House in committee for further consideration of the Coroners Amendment Bill, for consideration of the Riccarton Racecourse Development Enabling Bill, the Riccarton Racecourse Bill, and for consideration of the Social Security's Extension of Young Persons Services and Remedial Matters Amendment Bill. And we first turn to the Coroners Amendment Bill. When the committee was last considering this bill, we were debating Part 2. The Honourable Phil Goff had the call and there's 20 seconds remaining. The Honourable Phil Goff.
Thank you, Mr. Chairman. I want to strongly oppose Clause 32 of this bill because it takes away from the families of New Zealand Defence Force personnel killed in action the right to have independent and open scrutiny of the circumstances of the death of their loved ones. This is not what the families of Defence Force personnel want, and there is no justification, Mr. Chairman. Mr. Chairman,
Phil Goff.
there is no justification for this clause to go into the bill. I want to quote, sir, firstly, from a young woman whose name is Sarah Erb, and she is the partner, or was the partner, of Corporal Lance Tamatea, who was Luke Tamatea, who was killed in August 2012 in Afghanistan. And what she said, sir, was that the coroner's report into his death had helped her and Luke's mother to get answers and to gain closure. She said, and I quote, "Without that report, we'd feel quite ripped off. That's our loved one, and we should know what happened." Now, I want to put to the Minister in the chair why the loved ones of those who die in the service of their country should be denied an open and independent inquiry into the death of those service personnel members. We have that at the moment. The fact that we have this amendment before the House is because the Defence Force took umbrage that an independent person could look into the death of somebody killed in action and maybe reflect on issues that pertain to national security or military tactics. That's not what the report that caused this particular change actually did. You can read Coroner J.P. Ryan's report, and it is a straightforward explanation of the circumstances of death of 3 people who were killed on that day, the 12th of August. The families of those military personnel members have the right to have such an inquiry. Without the coroner's right to inquire into the death of somebody killed in action, there is no mandatory report that is required into those deaths. What usually happens, however, Mr. Chairman, is that the Defence will set up a court of inquiry into it. What's wrong with that? Well, what's wrong with it is, first of all, that it's in secret, and secondly, it's not done independently. And Defence Force personnel members themselves fear that such a court of inquiry could be more concerned not about what caused the death of those soldiers, but the Defence Force protecting its own reputation, because this is an inquiry by a body into its own actions or lack of action. And that is exactly what the families are concerned about. Sarah Erb said she didn't receive any information back from the Military Court of Inquiry. How can that be satisfactory for somebody who has lost the person that they love in conflict? Now, Mr. Speaker, Mr. Chairman, it's not just the families, though they, in my mind, are the most important people in this, but also former Chief Coroner Neil McLean, who said that this is a backward step. He said this proposal is out of step with other countries. And I want to read to the Minister what Chief Coroner Neil McLean says. He says, quote, "It flies completely in the face of what the Australians and the English have been doing for a long time, which is real cooperation with the colonial system." He said, quote, "Next of kin sometimes aren't too happy with military investigations. For better or worse, our society has said it's important to have some independent judicial officer with sufficient power say what's actually going on here. What are the facts? Are there any lessons to be learned?" He said, "The moment you start to erode that power and say it's only if it's not a combat death, that's representing a watering down in the power of the coroner." So I want the Minister to tell this House why he's ignoring the recommendations of the former Chief Coroner, why he is acting in a way that flies in the face of what the family of Defence Force members who die in combat actually want. Mr. Chairman, this was not the only option in front of the government. I have read the regulatory impact statement. I hope the Minister has, because he'll see in that there was another option. If the government is genuinely concerned about national security issues, why not have the default position that the coroner will hold an inquiry and then give the the Attorney General, Mr. Chairman,
Phil Goff.
then give the Attorney General, if it transgresses on matters of national security, the right to suppress that information. That would automatically allow the coroner to do what the coroner to date has always been allowed to do: inquire independently and make his findings or her findings open to the families and to the public and the people of New Zealand. That, sir, was something that the regulatory impact statement said would find an appropriate balance. A balance between the need for independent scrutiny and a balance with the need to protect national security issues. So I have a supplementary order paper before the House that says that option D of the regulatory impact statement should be the option that this House votes for, not the option that the coroner has ruled out unless the Attorney General says that he can do it. And when I put that to the Select Committee examining this bill, there was on all sides of the House sympathy for that position. That position was not adopted by the Select Committee because the Minister said no. Well, I want the Minister to get up and publicly justify why he is suppressing the facts of deaths in these circumstances when that's not what the families want and it's not what the coronial system says is necessary, Mr. Speaker. I think this bill is a backward step. I think that this bill is not about protecting national security. It's about covering up the circumstances that might prove embarrassing to the Defence Force or the government, and that is not something that is tolerable here. Sir, the report that was given to the Chief of Defence Force, I got under the Official Information Act, said that this isn't even necessary. It said concerns were raised that the issues that were driving this change are addressed by amendments in other parts of the Act. It says that this is based on one particular incident and it's not the norm, sir. It says that this will create a negative perception from families and the media about how deaths will be investigated. This is the information being given to the Chief of Defence Force. So it raises concerns about the option that the government has taken. It says that courts of inquiry are not mandatory for deaths by hostile action. That means that there will be no mechanism of mandatory investigation into deaths of this type. Is that a tolerable situation to have where our men and women die in combat and there is no mandatory system to investigate in any way the decisions that led to their deaths. I think that there has to be such an investigation, but it shouldn't be a closed investigation by top brass in the military looking at their own decisions. How can that be independent? How can that gain the confidence of the families and the people of New Zealand if it's not even out in the public arena? This is something that deserves to be in the public arena. If we don't learn from our mistakes, we are doomed to repeat them. You learn from your mistakes when you openly and transparently investigate them and make that public. And then there'll be pressure on the system if there's some inadequacy. It might be that there's an inadequacy of the way people are trained or the way they're equipped or whatever. But we have the right to know that if it's our families that are being put at risk and that are dying in combat, sir. The regulatory impact statement said that if the option I'm promoting in my SOP was adopted, it would find balance. So I want the Minister to say, why is he taking away that balance? Why is he taking away from those families the right to have an independent scrutiny of what happened when their loved ones were killed? Because we have had from government no answer to that question, no real justification to what they're doing. And I am asking genuinely of the Minister, please consider the alternative option that both the Defence Force said to its Chief of Defence Force would be okay in covering some of the concerns they had, and that the regulatory impact statement said found a proper balance between the needs for national security and the needs of the family to be satisfied that everything that should have been done was done, and that they are allowed to know why they lost their loved ones in action.
Jacinda Ardern.